I had a chance to meet many of you, and I'm sorry I couldn't introduce myself to each of you because I wanted to get a sense of who was in the room. So just a quick show of hands, who's working with a startup right now? Okay, almost all of you. Okay, and how many of you are actually in market? Some. How many of you are about to launch? So, and how many of you are earlier stage than that? The rest of you? Okay, great. Well, thank you for having me. My background is in consumer products. I've also done a lot of work with startups because that's my real passion. I think innovation is where it's at, and I love the white space on the map. And so I've worked with companies who are B2B, B2C, a variety of industries. And I've done a lot of work with UW, and I love partnering with UW. And any chance I have to help them, I like to take advantage of. So we'll spend about 45 minutes with me sharing some of the slides. I've got some handouts for you, and there will be some quick exercises that you can do to just kind of practice on your own value proposition as we go. And I'll leave time at the end for questions. And if for any reason I don't get to one of your questions, I've left my card at the back of the room, and I'd be very happy to take a call or an email if I didn't answer something that was really burning for you, because I want you to leave with something that you can use. Let's talk about creating a value proposition. How many of you are dog owners? Some. Do you remember how that dog came to be a pet of yours? Well, there's a lot of reasons a dog can get into the house, and it might be a dog would teach my child responsibility. That's a nice, rational answer, and it's a good way for an adult to kind of justify the dog. But probably what happened was something more like this. You probably had a whole bunch of different conversations going on, you know, lobbying for the dog on one side, and, you know, who's going to walk it? Who's going to take care of it? Is it going to pee all over the house? On the other hand, everybody's got to have a dog. Everybody should have one. You know, what are those pros and cons? And you'll also notice there's different people involved in that decision, and for each one of them, they've got pros and cons for getting that dog into the house. A value proposition from a company's point of view is going to be, what are we offering? So let me give you a minute to take a look at two really well-known definitions. American Marketing Association is what is promised by your marketing and advertising and sales, and then fulfilled by everything about your experience. So it's a contract. UW Lean Canvas, how many of you guys are using Lean Canvas? You know about it mostly? Some of you do, okay. It's the single, clear, compelling message that says, why are you different and worth buying? And we want to cover that today, but I want to do it from a different point of view, which is the customer's point of view, which is really simple. It's what I get versus what I pay in human being terms. And both frames are valuable. Writing it from the customer point of view is very critical, but if you want to really advance the quality of your work, if you can imagine yourself in your customer's shoes and think about it from what they will respond to, because it's really about you feeding them what they need. So why do you have one? That's a good question. First of all, it's about focus. You want everyone in your company to understand what it is you're doing and why are you doing it, and that will help you prioritize things like what's your minimum viable product. It'll help you decide how to answer the phone. Every decision flows from what you're trying to offer. And people could decide whether to choose you or not. So that could be investors, it could be potential employees, it's certainly going to be potential customers and any other partners you work with. So it's a great way to galvanize everyone around your mission and to focus your efforts so you can say what's not on your list. Making sense so far? Okay. Those of you using Lean Canvas, you're already working on value proposition, and I just want to let people know where that fits. The step number one is you start with a target segment and say, who am I serving? And then the second step might be, what is my unique value proposition, and what's that single, clear, compelling message that says, why are you different and worth buying? So it fits there. And a framework that I've developed over the years is sort of a hybrid of some real mental giants. They are Procter & Gamble, Frito-Lay, and Jeffrey Moore. So this builds on the shoulders of giants, and I thank them for this. There are different versions of this running around, so if you happen to be talking to a venture capitalist who prefers one way of expressing it, use their version. This is one of my favorites. So it talks about who are you for, and in this case it's some target consumer who has a problem. What do we offer? That's defining the category you compete in. So if it was a potato chip, it's other potato chips. If it's a medical device, it might be competing with other things that the medical device substitutes for. That delivers a benefit, so how does it solve their problem? And the reason you believe it is because you have this, that, and the other differentiating proof point. So that could be intellectual property, it could be a unique process, it could be evidence that a trial is working, making sense? And the optional section that you don't hear talked about, but is important to consider is what is the customer paying in hard dollars, time, risk? Because in their heads, they are trying to make that judgment. Is this worth making the leap to accept you as my new provider of whatever it is? Okay. So I wanted to take you through a couple examples to give you an idea of what that might look like. Everyone knows who Uber is? Some of you are laughing like, yeah, I do. Okay, so the business to consumer value proposition would be something along the lines of for people who just need a ride, not a car. Uber is an on-demand cab service, so you can tell it's competing with regular taxi cabs, that offers the easiest way to get around at the tap of a button, so ease and simplicity. Because you can get a taxi or a car or a ride share right from your mobile phone, that's very convenient. Uber connects you with a driver in minutes, that's very convenient. Your credit card will be automatically charged, and that's dangerously convenient. Okay. So all that's required is for you to install the app and create your account in minutes, and then prices reflecting demand, it's up to you to say yes to the price at the time. So that's Uber from the consumer's point of view. Uber from the contractor's point of view would be for people who want to be their own bosses. Uber's an on-demand cab service, same company there, that lets you earn money as an independent contractor because you get paid in fares for driving on your own schedule. And then all that's required is this long list of requirements. You've got to be 21, your car has to be a certain age, you can't be a felon. Now that's a long list, as you see, and so one of the things that Uber was doing was offering bounties to people who signed up to make it worth their while. So when you saw it in their advertising, look at that, I'm not working for the man, I am myself, I am my own man, and that shows that a picture's worth 1,000 words. So one of my points about value proposition is a lot of times it's nonverbal. If you can show it and not tell it, if you can show it in a picture and not tell it in words, there's many ways to get your value proposition across, and this is really powerful. Okay, let's try another one. Choice of target is critical, and I want to take you through a UW spin-out example. Does anyone know the company Mehta Phi? They spun out of here several years back. It was founded by Derek Street, who was an entrepreneur in residence. His daughter had a really unusual medical condition, and he really needed to find out everything he could about her condition so he could get her the best care possible. But when he went online to look at all the different databases, it was all over the map, and he got real frustrated. And so he created a company around solving the problem of making it easy for people to find that information and sift through it and find the most relevant clinical trial stuff, white papers, all kinds of stuff that would help you. And in the beginning, they were pretty clear that they wanted to focus on a couple of conditions first, like breast cancer or leukemia, and they're figuring that out. And that was one aspect of looking at the target is, what segment. But the thing that really surprised them later, they got into market and they discovered that it wasn't the parents or the caregivers who cared the most, it was the doctors. Because even though the doctors knew about all those systems and were really adept at getting things out of them, this was a step of convenience that saved them incredible amounts of time. And so, lo and behold, it turned out to be a B2P to physicians. So you got to be prepared to pivot, but the most important thing is that the choice of target might change on you. Just keep your eyes and ears to the ground and test that assumption a lot. It's very important. So this is a chance for us to take a quick exercise. Using your handout, take a minute to think about what product or problem or unmet need are you solving just jot down some high-level thoughts on it. And who do you think is your target audience that cares the absolute most about it? Just to think through this question. And circle the ones that you suspect might be most important. And for those of you who are already in market, you probably already have decided on that. Just to get your juices rolling here. Let me take you through Opta, which is a different kind of startup. That's another Seattle startup. This is a B2B value proposition. So for corporate travel program managers who hate to overpay, Opta is the travel price assurance expert that allows you to book airfare and hotels with the confidence that you'll get the lowest available price, because Opta automatically gets you the refunds when prices go down without disrupting your traveler's plans at all, typically saving 1% to 2% of the travel budget. So that's very clear. All that's required is to pay based on performance or by transaction, and you'll be up and running in 2 weeks, 3 weeks, no software changes. So one of the things that you can see that's implied in here is hating to overpay is kind of an emotional benefit as part, it's not just not wanting to overpay, it's like there's something that, they know that either their job is on the line or some of their top flyers are going to come into their office and show them a lower fare that they should have known about and embarrass them. So there's not only the functional aspect of that, but there's the emotional aspect in there. They also imply how easy it is because things are automatic, and so that addresses a preemptive address of, is this going to be a bigger job for me to kind of keep track of this, or is it actually easier and helpful? So that was an example of a B2B value prop. Making sense? Okay. So here's their ad at the time. Someone is flying on a lower cost ticket, which really was saying, don't be a chump. Don't be stupid. Don't be caught up. So you'll see how it's a rational explanation, but there's an emotional undercurrent to it that's really powerful. And then there's the real specificity. You can save this kind of money. How's that sound to you? And at the time, I took this from their web. I think they were debating whether to go after total trip savings, ticket savings. So they're still playing around with that. And that's important that you continue to experiment with how you express your messaging, because one version will be better than the other, and you'll only know by experience. And the marketer in the room is nodding at me. Okay. So that was the other way they were looking at this. I mentioned before that there's elements of rational and emotional aspects to a value proposition. And why is that important? Because now the neuroscience is in. Most of our decision making is coming from our lizard brains and not so much from our frontal lobes. And don't get the right, I don't know the names of the parts of the brain, but the rational part of the brain that thinks it's in control is almost never in control, even if you're super rational. So what you want to be doing is thinking about both the rational and the emotional stuff, because if you can tap into it, then you've got a really powerful value proposition. The best proofs for your value proposition are to demonstrate it. Showing, not telling is enormously powerful because it engages all of your brain, it engages your heart, all of it. It's the most experiential proof. But if you don't have that, testimonials from people like your customers that they would be likely to trust are also very powerful. So if you've got an expert who's just like you, that you can trust, you're going to take that person's word more than they're going to take your word. Very important. And supporting facts, the more specific you are, like Opta, I saved $260, our customers are saving 1% to 2%. Those are real numbers that they can back up. That is powerful also, but that's on a rational level. So quick exercise, we're going to move through the pieces of value proposition. Think back to what category you're really competing with for a second. And then if you can also think about what rational and emotional benefits will your target get from using what you're doing, and what makes you uniquely able to deliver these benefits. So take 2-3 minutes to scratch down some ideas. Okay, all right, I don't want to put you on the spot. If you've got something, keep it on your paper and that would be fine. So now we'll talk about what we pay. Remember that dog? Well, this is everything you're worried about, right? What you pay is a big hurdle, obviously, and it's important that you be really understanding what your target might be thinking they have to pay, really having to pay, both the sort of logical stuff and the stuff that might be not so logical. So remember your mom. This is my motive. This is from a friend of mine who does communications that move people to action. You have to have the motivation, you have to get over the objectives, and then that means you move. So think about what your target has to go through. And there are experts that say you need something like a 10-to-1 ratio of the motivation versus the objective to get people over the hurdle, and I don't know how well studied that is, but it's not a 1-to-1 for sure. So here are some examples of motivations, like what I get, and obstacles, what I pay. The functional benefits are the ones that are going to come up the most, because that's the stuff that everyone knows to talk about. So they can be financial, it can be convenience and time savings, it can be life-saving or extending, it can be a better experience. Emotional benefits might be safety and security, or reputation and status. If I go with this company, I know it will be a good company to associate with. That's good for me. Self-expression. I'm an Uber driver, and I am, an independent person. Whatever it says about me. Objections can be hard costs, like financial. It can be perceived or actual time and effort to consider, buy, use, and maintain. So it's not just getting it, it's using it. I'll talk about that a little more later. Soft obstacles can be a fear of buying from a startup. Someone might argue that's a hard one. Inertia, fear of making the wrong choice. I would rather do nothing than be wrong. It's not a top priority. That's a huge one. Like it'll never make it to the top of the list. Worried about how others will react if you do something. Can anyone think of any other either motivations or objections that might apply in your area? Because this is an incomplete list. So just think about it. This is not a full list, but you want to again put yourself in your target's mindset and say what would stop them. If you can tap into any of these basic human needs, the deeper you go with Maslow's hierarchy of needs, the more powerful it is that you're going to be. When I was working at Pepsi, you'd think there's no reason to drink Pepsi versus Coke. Well, one of the things we did was we connected a target of teenagers whose overriding desire is to show who they are, that they're not their parents. So we were able to tag into their feelings of either esteem or self-actualization, depending on how you want to target it. If you choose Pepsi, you're going against the status quo, which is what teens do. And that was globally relevant for people. Okay, so another quick exercise. What is your target going to pay in terms of time, money, risk, emotional costs, and can any of those be minimized by you? What could you address directly in the value proposition statement itself? And which might you show and not tell? Just take a couple minutes and think about that. Okay. I know I'm not giving enough time, and I apologize, but hopefully you'll get enough of it in your minds that you can do this at home. Let's talk about another dimension of value propositions, and now we're going into uncharted territory for most academicians, and most startups aren't really talking about this yet. This is sort of my own work and the work of my colleagues. I will not keep calm, I'm quitting smoking. Value propositions may change over time for people. And this is kind of like out there. But there's the decision to quit smoking where you're addicted and you enjoy smoking. That's the reason you're doing it, but you're going to die sooner pretty well. So you don't want to die, so probably the value proposition is pretty compelling. But then you start to quit. I'm saving some money, I can taste my food again, but I'm gaining weight, and I have nicotine withdrawal, and I'm cranky, and my family's unhappy with me, and this is not going so well. And this is where you need something extra in your value proposition, and you go and talk to your friends, and you go to support groups, and you get the nicotine patch, and suddenly you've got more help. But that's a lot harder to stay quitting than it is to stop in the first place. And then ongoing, finally, you get the benefit of all this. My lungs have cleared up, my family's happy, and I'm going to live longer. So there's sort of peaks and valleys throughout the process. And so a value proposition is usually written from the point of view of that earlier stage. But don't forget to think about the later stages as you get into it. So the stages in marketing terms are called consideration. I'm thinking about buying you. Then there's the purchase and buying and starting to use you. And then there's repeat, use over time and the benefits of all of that. So that's the sort of formal marketing structure. And some people call it trial, onboarding, ongoing use, depending on your business model. But you get the idea, right? So at the consideration stage, you have the promise of a better solution, but not the experience of one. And you've got the cost and the risk. That's pretty tangible, and the promise is not so tangible. The purchase, now you're actually getting the benefits, and now you're realizing there's some cost to maintain them, and there's is the customer service delivering? Is it good? Is it impossible to get help on the phone? That kind of thing you have to think about. And then when it's time for someone to renew or to buy it again, they're starting over, but are there switching costs? Maybe we can do this cheaper, better in-house. Are there new alternatives? So, people are always comparing you over and over again, so just keep an eye out for that. Okay. So, quick exercise. Which benefits are going to be the most motivating at each stage? If you think about just like once they bought you, which costs are going to be the most difficult to overcome at each stage? And which might you want to address in the value proposition statement up front? Because if people know that the cost of smoking, it's going to be hard, then maybe you need to address something up front, even though they haven't gotten there yet. Okay, just a couple minutes here. Okay. Now let's talk about actually when you write them. Being specific, as I said earlier, was really important. And you can either have a flabby statement or you can have a crisp statement, and you want the crisp version. So if you see blah, 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 best of breed, innovative, fast, powerful, easy to use, cost saving, awesome, could that be made more specific in some way to make it really sharp? Number one as rated by US News and World Report. We're the only people doing this, or we're the first. We're faster than a speeding bullet. That isn't as precise as you could get. You really want to say it happens in a nanosecond. More powerful than a locomotive. Really what I mean is you can lift twice your body weight with this new vitamin. Takes 5 minutes, not just fast. Saves you 10%, like the Opta example. And if it's really awesome, if you show it to them, you don't have to tell them it's awesome, right? So look for ways to really sharpen your arguments so that you can tell your story in the best, most powerful way. Okay. So to summarize, the considerations for value proposition, number one is your choice of target is critical, and you're likely to have to test those assumptions out throughout your life as a company. Decision making is both rational and emotional, so consider the emotion as well. Remember your mom, motivation minus objections equals momentum. The value proposition needs to be compelling at every stage. And your statements in plain English and be as specific as you can. And if you follow those, you'll have a much better value prop. A word about writing them, they're tough. They're really tough. It'll take you a while. You'll wrestle with it. You'll throw it away. And you'll find one you like, and then you'll get into market, and you'll realize something isn't quite right, and you'll have to redo it. Expect this. This is normal. They're even tougher to deliver on. You might want to have the best-in-class customer service, but delivering that is no mean feat. You need to validate it and refine it, so getting out in front of your prospective target audiences and others that might be also candidates, getting out a lot and showing them your stuff and hearing what they have to say about it. Do they really have this problem? Is it a really painful problem? Is it a problem that only you can solve? Asking those kinds of questions is really helpful. And then you'll know whether you're digging in the wrong spot. Very important. And expect it to evolve over time. Like the Mehta Phi example, they got in with a perfectly reasonable hypothesis and discovered there was a better one. So don't be afraid to keep looking for the better one. And you'll have fewer messes as a result. So at this point, how much time do we have for questions?
About 20 minutes.
20 minutes for questions? I'm happy to answer them either in public or in private. Okay. Well, I'll stick around, and if someone wants to ask me something while I'm still here, I'll be here until about 1 o'clock and happy to address questions or whatever else you might have to ask. Thanks for your time.
No, thank you.
Right.
All right, thank you everybody for having us and for showing up to hear us talk a little bit about what is IP. As she mentioned, my name is Brad Zentz. I'm a 3L at the University of Washington School of Law, and Jake's a 2L. We're both studying IP. We're both planning on entering the market to practice. I'm going to be doing patent prosecution. Jake's still not sure, maybe patent prosecution, maybe patent litigation. And then we're supervised by Robert, who's in the very back. He is a real-life patent litigator at Dorsey and an all-around awesome guy. So we thank Robert very much for his help in making sure that what we tell you guys is accurate and accessible, and he's going to help us answer any questions if you guys have some tough ones at the end. On that note, we're going to cover 4 different topics today, which you're going to see here on the agenda, if I can get it to work. Because there's 4 main types of IP rights, and we're going to ask, if you would, please hold questions till the end, because we know that for some of you this might be your first introduction to intellectual property, and we want to make sure that we get through all 4 topics because they are important in their own right. And sometimes if you give a presentation, people are really interested in one aspect or another, and you start getting questions, you go down the road, you know how it goes, you run out of time and you don't get any training on the other categories. So with that, we're going to jump in. And the first thing is, what is IP? So if you were to encounter a new term just out and about in your daily lives, you would go online, right, to look up a definition. So if you were to go online and Google what is IP, you might get a response like the top one there from the World Intellectual Property Organization. And what you'll see in the definition is basically, the first part is kind of helpful. It says creations of the mind. The second part is basically just a description, such as inventions, etc. Is just a description of all the different types, as you're going to see as we go through this. So an alternative definition that's a little bit more helpful is basically intellectual property rights are something that are not tangible. They are still a legal right or a right to prevent others from doing something, but they're more of an economic and financial focus to protect your inventions, creations of the mind. And as I said, there's 4 main types: trade secrets, copyrights, trademarks, and patents. Jake's going to do trade secret and patent. I'm going to cover copyright and trademark. And the important thing to remember is that the forms of IP are not exclusive. And what that means is if you were to take your iPhone out of your pocket, all 4 types of IP might be involved in that product. So it's really important never to discount one or another. You can protect your inventions in many different ways.
All right, so we'll jump in, starting with trade secrets. Trade secrets, probably not the most well-known form of IP out there. It's an underutilized form of IP just because there's not really an application process. You don't really hear about it in the news as much as you might patent law and whatnot. But that's not to say it's not a very important and very economically sound business decision for certain companies to make to increase the value of their intellectual property portfolio. So jumping right in with what actually a trade secret is, there's basically 2 requirements for a trade secret. First, that some type of information that you have derives independent economic value from not being known or discoverable by the public. And second, it's the subject of reasonable efforts under the circumstances to maintain its secrecy. Now that's a very legalistic definition with terms like reasonable. So we'll break those down for you in the next couple of slides, starting with the first requirement. So the independent economic value. Essentially, this means that the information you have has to somehow give your business a competitive advantage. So information that's already public knowledge cannot be held as a trade secret because your business can't derive an economic advantage by by being the only ones who know that information. It's important to note the threshold of competitive advantage that you need to show is very minimal. It's easy to meet. In fact, it doesn't even have to be realized. It can be potential future value. So it's helpful to have an illustration or example of what a trade secret might be. So the traditional example is the formula for Coca-Cola. I don't know if you guys have heard, like, it's kept under, lock and key in a vault where only like 2 people can access it. So that's an example of what a trade secret is because it's a formula that's not known to the public, and it gives Coca-Cola an economic advantage for holding that as a secret because, according to the public, it's very tasty. So the second step to establishing and maintaining a trade secret is this reasonable efforts to maintain secrecy prong. Now, I just said that Coca-Cola keeps this recipe under lock and key in a vault. Now, that's not what you have to do for all trade secrets. Trade secrets are reasonable efforts to maintain secrecy. what this looks like and how to determine is you look to the customs of the industry. So, for example, if we're dealing with software or something along those lines, a lot of times documents in the form of non-disclosure agreements for employees and prohibitions on reverse engineering in terms of use for customers are reasonable efforts to maintain secrecy. So some quick examples of possible trade secrets. Like I mentioned, software, especially source code, can be protected under trade secrets. Unique algorithms, combinations of elements that aren't readily ascertainable by looking at the object, and then unique formulations, which is like the Coca-Cola formula that I mentioned. So some benefits of trade secrets that might not be readily apparent. First off, there's no application process like there is for patents. This is great because there's no fees associated with trade secrets then, other than establishing or drafting documents like non-disclosure agreements and maintaining those reasonable efforts. And third, trade secrets can last as long as as long as you meet the two requirements, the one being the competitive business advantage, the second being the reasonable efforts to maintain secrecy. And fourth, trade secrets are great because they encompass a wide range of subject matter. Basically, any information that gives you a competitive advantage is eligible to be protected as a trade secret. So it covers a lot of what can also be covered under patent, trademark, or copyright law, but it just gives you another tool to protect your intellectual property. There are some limitations to trade secret protection, primarily that it doesn't protect against reverse engineering or independent creation. What this means, I'll start with reverse engineering. Going back to my hypothetical about the Coca-Cola formula, if Pepsi were to be able to derive the formula of Coca-Cola from independent tests or from testing on their own, that would not be what's termed a misappropriation of the trade secret, which is the legal term used to denote when you're stealing someone else's secret. What would be misappropriation of the trade secret is if Brad here was an employee of mine at Coca-Cola and he was subject to an NDA telling us, or basically agreeing that he couldn't disclose this formula, and he was to go to Pepsi and tell Pepsi about it. That would be misappropriation, and trade secret law protects you against evil Brad.
That's right.
So the second thing trade secret doesn't protect you against is independent creation. So that would be if Pepsi was to, in their own independent lab, come up with the formula on their own. So just a quick summary, trade secrets exist from the moment there is a secret. It confers a competitive advantage and is subject of reasonable efforts to maintain its secrecy. There's no application process. Reasonable efforts depend on the customs of the industry, and it's a very important intellectual property tool that lots of businesses possibly already have but don't really realize it, and it's important to realize what trade secrets your business might have so you can ensure that you're taking the correct steps to maintain those trade secrets. With that, we'll move on to copyright, and I'll turn it back over to Brad.
Yeah, thanks. All right, so the scope of copyright is it protects original works of authorship, which are fixed in a tangible medium. And those are two terms that we're going to talk a little bit more about. So original works of authorship basically means that it has to be somewhat new, but not, it's not a very high bar, kind of like trade secrets. And fixed in a tangible medium means basically rights arise as soon as it's fixed, which, for example, is when an author writes a book or a programmer writes code. As soon as it's in some sort of savable media, whether it's online or on paper, that's your copyright. Another important concept is that copyright protects the expression of the idea, but not the idea itself. And this is a weird thing that we discussed yesterday with Robert, because it's hard to provide an example. But a good example is the idea would be a story about a young wizard coming of age, but the expression of that idea is Harry Potter. So you can't copy Harry Potter because that's copyrighted material, that's an expression of the idea, but you could write another story, completely different characters, different plot, with the same central theme, and that would be the idea. So the ideas are not protectable, it's the expression. So the nice thing about copyright is there's no formalities required to own one. You don't have to use a copyright notice. The rights arise as soon as you fix your expression. And the registration process is not required for ownership, but there are benefits to it, particularly from litigation. So you do have to register before you can file a suit to protect your rights. And there's also some additional advantages that come into play by registering early. But the one key about the registration process for copyright is that it's not very difficult, at least compared to patent and trademark. There's no extensive back and forth process with the government. It's much simpler, it's much cheaper. And there's information available on that on the US Copyright Office website. There's also really good, more information about copyright can be found with documents they called circulars, which are 1 to 5 page documents that are directed at the general public that explain all the different elements of copyright in a lot more detail. So the exclusive rights you get with the copyright are to copy, distribute, make derivative works, perform, and display. So as you can tell, copyright's pretty broad, and it covers a lot of things you see in everyday life. Movies, TV shows, even stuff on a website, code, all sorts of different things can be copyrightable. And then in terms of how long they last for, so the normal term for copyright is 70 years after the life of the author, so that's pretty long. But there's an important distinction, and that is for employees who create copyrights in the scope of their employment. So again, code is an easy example. You have your programmers working on something for you, and if they're within their scope of their employment, then you can make sure that the rights go to the employer, and in that case, it's 95 days from the date of publication, 95 years from the date of publication, or 120 years from the date of creation, whichever is first. So you still get quite a long term in that case, but it is a little bit different, just to let you know. So copyright in the infringement context is kind of messy in a lot of contexts. Because as you see, the easy case is when someone literally copies your stuff, which is going online and downloading something you shouldn't be downloading, right? But that doesn't happen very often, or at least people don't get caught for it very often, I guess. The harder case, which is much more common, is the non-literal copying. And what we're talking about here is something is similar, but it's not quite the same. And you have to prove that the sequence, the structure, the overall kind of impression has been copied. And that process is not very well defined. And so if you ever had to go down that road, we would definitely recommend seeking out counsel at that point. Like Robert, you can hire Robert. So that's just a little bit of information on infringement. And then on to trademark. So trademarks, I think, are kind of a fun topic to talk about because everybody knows what they are. I mean, we already threw around some important trademarks today, Coca-Cola, things like that. And it's really, I think, in my opinion, it's a pretty good idea for most businesses to try and get one at some point. So we'll talk about what they are first. So the key elements is that they are word, name, symbol, design, or combination, which is very broad. You can get a trademark on a lot of different things. And it has to be used in commerce. And the third one is really important. We're going to keep talking about this, which is they're about source identification and about distinguishing your source of your goods as a business owner from those of another. And at the bottom, you see some things that can never be a trademark. Functional aspects of a device. So you think about utility patents, which Jake will talk about more. That's for your functionality. Inaccurate descriptions, immoral, scandalous matter, which are bad words, things like that we don't want to be out in the public and protected. Things of that nature. So as I said before, the rights arise as soon as the trademark is used in commerce. And what that means is if you don't have to get a Fernow trademark registration to have some rights. If you just have your business here in Seattle, you have your business name and you're using it, you're offering a product or a service, then you have some trademark rights. The problem with that situation is that your protection is limited in scope to the Seattle area or wherever you're using it. Maybe it's Washington and Oregon. So to expand on that a little bit, if someone were to take your exact same mark and offer it on the exact same product and service on the East Coast versus the West Coast, if you had common law rights, you would have no action against them. You could not file suit against them, even though they are completely ripping you off. If you go through the federal registration process, which is not terribly expensive, as you can see at the bottom, although attorney's fees can often drive this up, then one of the major benefits is you get a nationwide scope of protection. So if you're just here in Seattle and Oregon and someone else rips you off, then you can go after them. So that's why I think it's kind of common to recommend them. In a lot of businesses you will see, I think Coca-Cola, for example, has hundreds, if not thousands, of trademarks on all their slogans, brands, everything. And another important thing is because trademarks are use-based in the US, you have to continue use or you might lose your trademark rights. And so a good example of this is you see companies launch a certain product within they have their overall trademark right, which they continue use, but they might launch a product they sell for 6 months or a year, and then they stop selling it, right? They move on to something else. In that case, then you would lose the rights of that trademark because you have to continue use in order to keep your rights. And inherent in that is you have to also protect others from copying you if you have a trademark. Because it doesn't make any sense, right? If you get a trademark and then you let other people copy it, there's no longer a source distinction attached with your mark. So in that case, your mark is no longer functioning as a mark and you can get it canceled. So if you wanted to go down the federal trademark registration process, what's going to happen is you can only register what's called an inherently distinctive mark. And again, that goes back to, well, if the consumer encounters this, are they going to know that you're the one source producing it? And so marks get placed on a spectrum, which you can see on the bottom, from left of the line, by the way, is bad, and right of the line is where you want to be. So generic is when the name for a product encompasses like all the different variations. So a good example would be like now Band-Aid or aspirin. People think of a bunch of different brands as being aspirin, and it's a word that's so commonly used that no one gets exclusive trademark rights to it. Descriptive is exactly like it sounds. If you hear it, it's describing the business. And one of the things that's important about this is that marketing people or marketing strategies often love descriptive terms because it's easy to sell the customer on the idea of, well, our business does this and our mark says this, and so we're going to tell the customer what we do and they're going to come buy our stuff. It's going to be great. The problem is you can't get a registration on generic or descriptive terms. It may be possible with descriptive, but you normally have to prove, like American Airlines can, that the consuming public associates your mark with that source, which is something that can be very difficult to prove, especially for smaller startups. On the right side of the line is where you want to be. So suggestive is the next step above descriptive, and basically the idea is if you see the mark, you won't immediately know. It might give you some idea of what's going on, but you won't immediately know exactly what that business does. And so a lot of good marks are drafted that are suggestive, and it's also pretty easy from a marketing standpoint. The other end of the spectrum is where you can get the broadest rights because you have what's called like a strong trademark because it's arbitrary or fanciful, and these are like your made up terms or maybe a word that already exists like Apple but used in connection with something completely unrelated. And so those are great from a trademark standpoint. They're the easiest to register, but they're the most difficult to market. So that's just something to keep in mind as you might want to change your name or you're thinking about doing trademark registrations, just something to think about. Another important aspect of trademark that people don't commonly think about is actually trade dress. So this is product packaging and design, the overall look and feel. So going back to the iPhone example, I mean, it comes in a white box, right? And it's very distinctive. That can be trade dress. Or even like the icons on your phone, the way they're arranged. It's an example Jake will touch on later. These are all possible trade dress opportunities. So if you're selling an actual physical product, that's another avenue that you can think about particularly if you don't want to go down the patent route. It's another way. As long as your trade dress is distinctive of source, then you're still okay. And then in the infringement context, we've already kind of touched on this, but it's basically someone uses a similar mark on similar goods as you, but only after you, of course. So in this context, another example is helpful. So you guys are aware of Delta Airlines. I'm sure American Airlines is aware of them as well. And then Delta faucets, which are your bathroom faucets. So in that context, if you're a consumer, you're not confused because you wouldn't expect Delta Airlines to sell faucets and you wouldn't expect a faucet company to sell commercial airline flights. But if Delta Airlines says, well, we're going to go into the bathroom tile business, well, you would assume, or you might think, that tile and bathroom faucets are related. And in that case, you might have a good case for infringement. So it's kind of the question is really, it's a relatedness, and the key is the statutes and the law protects against consumer confusion. So if you're using the exact same mark on very, very different goods and services, there's no confusion and you should be in the clear. But the closer that those two get, the more the question becomes whether one of the other parties is infringing. And then on to Jake for the last section, patent.
Okay, last but certainly not least, we have patents. So a patent, it gives the owner the right to exclude others from making, using, selling, offering to sell, or importing into the United States the patented invention. It does not give the patent owner the affirmative right to practice the invention. This can be in the context of whether it's, you're a pharmaceutical company that's getting a patent on a drug that hasn't got FDA approval yet, or if your patent builds on another patented invention. That's why the statute is written in the negative and gives you, the patent owner, the right to exclude rather than the right to practice. there are three main types. Well, there are three types of patents: utility, design, plant patents. The remainder of, or the majority of this discussion will be focusing on utility patents, which is probably the type of patents you guys have heard of in within coming up through your business or whatnot. It protects the function or the utilitarian features of your inventions. Design patents protect ornamental designs. So it's helpful, this example here, the rows of applications and how it's displayed on the screen of this iPhone over here on the right, that could be covered by a design patent because that doesn't speak to function as much. Whereas here, it's kind of hard to see in this picture, but this phone is actually submerged in a glass of water. So the fact that it's water resistant, that's a functional aspect of that item, and therefore that would be protected with a utility patent. The third type of patents, plant patents, I'm not going to touch on them at all. It's a very, very rare category that likely most of you in your business will not have to be concerned about. So any discussion about patents begins with what subject matter is eligible for patent protection. There are four categories your invention has to fall in to be patent eligible. The categories of process, machine, manufacture, composition of matter. Almost every invention you can think of falls within one of these four categories, so it's very broad and easy to meet this first step. However, there's certain exceptions, things that over time for political and economic reasons, it's been decided that they aren't subject matter eligible, and these are abstract ideas, natural phenomenon, and laws of nature. There's a lot of uncertainty and change in the law right now relating to what exactly these terms mean and what level of inventiveness you have to meet in order to overcome one of these exceptions. Briefly, an example of an abstract idea would be an algorithm, or a lot of inventions relating to computers and software can get denied at the patent office because they are considered abstract ideas. An example of natural phenomenon would be like an isolated DNA sequence, something that's occurring in nature and you're not changing it, you're just isolating it. And then laws of nature could be a relationship that occurs in nature, whether it be involved in medical diagnostics with, like, if you have a protein serum level of X, it means Y. Discovering that relationship can be very beneficial to science, but it's no more than a discovery, so it's been held that that is not patentable. But like I said, there's a lot of change going on in the law right now with respect to that, and there's a lot of uncertainty. So it's hard to speak in absolutes. Once you've met the subject matter eligibility, you also have to meet the patentability requirements. These are that your invention is new, it's non-obvious, and it's useful. So new essentially means that whatever it is you're applying for a patent for hasn't been publicly disclosed before. And non-obvious means that the invention has to be more than an obvious combination of known elements. The standard you use when determining if something is obvious or not is you're looking at it from the perspective of a person having ordinary skill in the art. So if, for example, your invention related to nuclear engineering, I wouldn't be considered an expert because my background's in biotechnology. Brad, if he was a nuclear engineer, would be the standard that the patent office would use to determine whether, okay, there's A and B out here. Does A plus B, is it obvious to combine them to equal C? If yes, your invention is obvious and therefore not patentable. If no, it's not obvious to combine these two known elements, then it can be patentable, assuming you meet the other requirements. The third one I touched on, utility, it has to be useful. This is a very, very low bar, and it's very easy to meet, so I won't go in depth on that. There's also, for your, just so you're aware, there's a written description and enablement requirement. These are requirements that arise during the actual drafting of the patent application. So they're not something you have to meet before, and they don't have to be in consideration prior to actually filing the patent. And whatever attorney you have drafting your patent application would be able to help assist you in better understanding and meeting those requirements. So when you're determining whether your invention is new and non-obvious, you'll hear this term prior art thrown out there. And what prior art is basically any information that has been disclosed to the public. This can be prior patents. It can be patent publications, which means essentially patent applications that have been published and are available for public review. It can be journal articles. It can be conferences. Like if I was up here speaking about an invention, that would be a public disclosure. And it can be selling an item. This is also a non-exhaustive list. So basically anything where you're talking to the public or disclosing to the public information about your invention. It's really important to know that your own work can count as prior art against you. So it's important to be aware of what are known as the statutory bar dates, meaning if I'm an inventor and I invent something that's really awesome and I want to tell people about it or I want to publish a journal article about it, I need to be aware of the dates I need to have my patent application filed by, so my presenting on my invention doesn't prevent me or doesn't make me lose any future patent rights I might have. And those dates that are important is if you publicly disclose the information, you have 1 year to file your patent application from the date you publicly disclose. And it's important to note that foreign jurisdictions have what's termed a grace period, this 1 year period. So if you're seeking international or foreign intellectual property rights, it's really important to consult an attorney that's familiar with that jurisdiction before making certain public disclosures in order to preserve the right to pursue a patent. It's also, I'll go into a little more detail on the actual timeline here, but patents aren't fast. The PTO does not operate quickly. It's very common that from the time of filing a patent application to the grant of a patent can be between 3 to 5 years. So it's not a quick process. Here's a little more detail about the actual timing of the process. So if you conceive of the idea down here, make an initial public disclosure, let's say you publish a journal article, you must file your patent application within 1 year in order to prevent being barred by your own prior art. You'll have your application will be published in 18 months from the date of your filing. This means the public will be able to view your patent or your patent application even though it hasn't issued. You'll receive what are known as office actions. This is essentially the USPTO, which is the United States Patent Trademark Office, the governmental organization that examines patent applications and decides whether or not to grant them. They will look at your patent application, they will look at the prior art that I mentioned earlier, and they might write you back and say, well, reference A covers a lot of what your patent application covers, so you need to make some amendment or narrow what you're claiming as your invention in order for it to be patentable. So you'll have kind of a back and forth dance with the patent office. And then your patent issues, like I said, 3 years from filing. It's not uncommon for it to be outside that range either. And then there are things known as maintenance fees. So essentially 3.5 years, 7.5 years, and then 11.5 years after your patent grants, you have to pay maintenance fees. If you fail to pay those maintenance fees, the patent will die essentially, and the information can be freely used by the public or the invention. And then patent term, you have 20 years from the filing date back here, and that's how long your patent lasts for. And then after that expiration date, you're dedicating the invention to the public, meaning you can't assert your patent rights going forward. Costs, it's important for any business to understand the cost of patents. Patents aren't cheap. There's 2 categories of costs. One broken down here is government fees. The other one is attorney's fees. I'm not going to go in depth on attorney's fees because there's a wide range of attorney's fees depending on the type of invention and the law firm you go to. As for government fees, these are the basic fees you need to pay during the process from filing the application to the end of the term of the patent. So it includes the maintenance fees. There's 3 different categories I have up here. What these categories reflect are you get discounts if you meet certain requirements, namely if you're a small business or an independent inventor, you can meet these requirements and get reduction in fees. They're very specific requirements that I probably don't have time to go into detail on right now. But suffice it to say, if you're a startup, a small business, you would likely meet at least the requirements to be small entities, so you would be in this column. But you can still see across the total life of the patent, it's still pretty expensive. You're looking at $7,500 there. across the life of a patent, nearly 4,000 if you qualify for microentity status. But that is over the 20-year period as well. So kind of to take a step back and talk about why you might want patents in the first place. One, monetization reasons. There's lots of opportunities for licensing that might arise. You can sell patents. If you sell your company, a lot of the value attached in your company will actually be from patents and what your patents cover. Kind of going along those same lines, if you're seeking investment, outside investment, whether it be angel investors or venture capitalists, they're going to want to look at your intellectual property portfolio and see what you actually own, and patents are going to be a major part of that likely. They want to make sure that you have robust protection because they don't want to make an investment in your company and then turn around and see that a competitor can basically do the same thing as you are because you don't own your IP. Likewise, you have some control if you have patents. It can prevent larger companies from basically forcing you out of the market because you can prevent them from practicing whatever your patent covers. So we're going to move on to questions. I just want to real quick say that I think next week there's a more in-depth presentation on patents, and the following week there's a more in-depth presentation on trademark and copyright. So hopefully this, if you guys are interested in coming back, hopefully this provides a good kind of starting point. But at this point, Brad and I would be happy to answer any questions, and thank you for your time.